Now, we're going from the general, the policy issues here, to the particular. Lenny and Darcy are going to talk to you, are going to give you an overview of the changes. And this is where you might need to get your pencils out and concentrate. We've got an hour to do this. If they are able to accomplish this Herculean feat in less than that time, they may be able to entertain some questions. I'll turn it over now to Len.
Darcy and I have spent a good part of our time since the regulations have been released trying to dissect these regulations and put together something that hopefully will be helpful to you. As indicated by our title, Darcy and I will be giving you an overview of the major changes that are contained in the new SABS. Don't panic when you listen to us. We're just giving you an overview. Wherever there are serious issues, they're going to be tackled by other speakers. So there will be a lot of questions that will come out of our presentation. Don't worry about it. Hopefully those questions will be answered for you by the other speakers. At the end of the day, if you have further questions, the panel will certainly be able to deal with those. Now, Darcy and I have worked hard to try to put together some material as well that will be useful to you as takeaway resource materials. So in your binder, you will find, and you may want to just turn to these things because it may help you to follow along with a couple of them. At tab 3 is an overview that Darcy and I have prepared, which is really a comprehensive review of the changes. And it will contain some of the comments that you will hear from other speakers today. And then at the front of your binder, you will find 2 charts. The first chart is a summary of the benefits, and Darcy is going to be taking you through that chart to help you sort of work your way through it. And the second chart is a summary of what we call the top 20 changes to the new SABS. And that's what Darcy and I will be taking you through in the second part of our presentation. So, as I said, this portion of the seminar is to simply highlight the changes, outline for you what we see as the major changes, and then for the rest of the day, we're going to be tackling each of those changes in turn. So I'm going to turn it over to Darcy to deal with the first change in the benefits.
Good morning, everyone. For the purpose of the next few minutes, if everyone can pull out this fancy colored chart that's in the inside folder of your binder. It's the one entitled Statutory Accident Benefits Schedule Summary. Okay, so what I'd like to do now is to make sure everyone understands the new changes. Other speakers are going to be talking about them throughout the day. So we're just going to highlight them all. There are some footnotes here, and I want to make sure everyone understands how to read it. So, for example, in the bottom right corner, it talks about the red writing referring to the old SABS, pre-September 1, 2010 SABS. There's one asterisk signifies where those benefits incorporate the definition of the word incurred, which is going to be a large topic for discussion, and Craig's going to be speaking about that later. And then the double asterisk signifies where optional benefits are available. And nobody's going to be speaking at length today about optional benefits. There is, in our paper, a whole section on optional benefits. It takes you through the variety of optional benefits that are available. No one's really sure what the take-up's going to be on the optional benefits. Currently, optional benefits are available, and 3% of the population uses them, as some stat that's been floated. So they're very unpopular to date, and query whether they're going to remain unpopular. A lot of that will depend on the educational component that's supposed to come along with the optional benefit and the influx of the new optional benefit options. So I'm going to just take you through the categories, and there are 3 different categories of injuries under the new SABS. Minor injury, which takes over from the old PATH, the pre-approved framework. The non-catastrophic impairment, which is what we all understand and remains, and catastrophic impairment. So the chart segregates the benefits by those categories where there are differences. And just heading down through the left sidebar and the various benefits, I'm just going to highlight some of the points, and you'll see I'll refer people to where people are going to be talking about these issues later. When it comes to the med rehab benefits, for minor injuries, there's a hard cap of $3,500 with an escape clause. Okay, and we may refer to it today as an escape clause. And David Payne from our office will be speaking on minor injuries and the guidelines. In that green first column, it talks about what the guidelines, what the escape clause says, essentially. And if you get out of the escape clause, you access 50 grand in med rehab. On the non-catastrophic side, from the med rehab perspective, the cap's gone down from 100 to 50. It's a major change. It will have a negative effect on consumers. From a catastrophic impairment side, it remains $1 million. There's no change. And again, a lot of these are subject to optional benefits, and I'm not going to keep reiterating that. The next two lines deal with the costs of assessments, and we are going to be speaking shortly about the cap and about how the cost of assessments now come off limits, which is a negative impact that applies as well to catastrophic issues. So there is a reduction in the catastrophic benefits by virtue of that change. Moving down to the in-home assessments and examinations. Minor injuries, not available, can't be done. For other injuries, non-cat and cat, it is available, and that's there was some discussion about it not being available in non-catastrophic cases, but thankfully that was not adopted, thanks to good work of a lot of people in the room. So it is available in non-catastrophic cases, in-home assessments. Case manager services only available in cat situations. That remains, but there is an optional benefit that would provide case manager services in non-catastrophic impairment cases, and that's one of the more appealing optional benefit packages. Attendant care benefits, not available in minor injury cases. When it comes to the non-cat cases, it's been reduced from $72,000 to $36,000. Okay, so it's halved. Same 2-year period applies, but it's been halved, and there's a footnote that we're going to be talking about later about who can now prepare the Form 1 associated with the attendant care quantification. Catastrophic, there's virtually no change other than who can do the Form 1. Transportation, no change. Housekeeping and home maintenance, no longer available in the non-cat situations, in the minor injury situations as well. So that's gone, subject to optional benefits. The lost education expense remains. The visitor's expense remains. Damage to clothing, death benefits, and funeral benefits, they're all laid out there. I'm not going to go into those in any detail. Income replacement benefits, there's been a minor tweaking from what we used to calculate on an 80% net after-tax basis. It's been adjusted to 70% gross. That's to simplify matters. It's a sensible change. And then there's the non-earner benefit with no change. And the other hot-button issue is caregiver benefits. Has been eliminated for non-catastrophic situations and minor injury situations, for that matter, subject to optional benefits. So that's a quick overview of the changes. We're going to be speaking about a lot of the particular issues shortly, and I'll pass it back over to Lynn.
We'll be going through the next chart, one by one, the summary of the top 20 changes. So if you want to follow along, we're going to try to deal with them in order. The first change, which I'm sure a lot of you in the room have heard about, is the assessment costs now coming out of the medical rehab limit. So all assessment and examination costs, including the cost of preparing reports, now come out of the med rehab limits. A big, big change to what we're used to. Under the current system, case manager services come out of the limits, but the cost of assessments and examinations did not. Now they do. Now, what implications does that have? We know, as Darcy's just told you, there's been a reduction in the non-cat limits to $50,000. But it's worse than just a reduction to $50,000 because now the examination costs come out of that $50,000 limit as well. So it's not really $50,000, it's $50,000 less the amount of the assessments. So that's important to remember when we're talking about the limits now, the cost of assessments and examinations come out of that. In section 18.5, which is up in the screen, it sets out the actual wording. We've highlighted the wording that creates the new changes. The first paragraph in blue at the end of the red section, there's the words any benefit. And the reason that we're highlighting the words any benefit is that the cost of examinations or assessments in regard to any type of benefit, whether it's attendant care, anything, comes out of this limit. The only exceptions, and there are two set out on the slide here, are insurer examinations. They do not come out of the limits, and accounting reports to quantify income replacement benefits. Those do not come out of the limits either. Everything else does.
The second point in the chart, and again, we're just going sequentially, is there's a $2,000 hard cap on assessments. So I'm just going to read the section. It's up on the screen there, but just in case anyone can't read it. Section 25.5 says, despite any other provision in this regulation, an insurer shall not pay, so it's a prohibition, A, more than $2,000 in respect of fees for any one assessment or examination, whether conducted at the instance of the insured person or the insurer. So it's a hard cap of $2,000. It applies also to IEs, the insurer examinations, which is now Section 44. So it applies to that. It's for one assessment. So there were a lot of questions asked of fiscal representatives. Well, how do you deal with the multidisciplinary assessment centers where they arrange 4 assessments? Is it $2,000 for the whole, all of them included, so $500 per? And the answers we got suggested that it could probably be $2,000 per assessment. Now, nobody knows how the section is going to be interpreted, but that's currently what the understanding appears to be from the Financial Services Commission, that it's $2,000 per assessment. Notably, and there's a footnote at the bottom of our slide here, in reading Section 25.5, they've omitted the words preparing reports. And Len just took you through 18.5. I'm just going to flip back forward to it. But the words preparing reports are there. So when they talk about the costs coming out of limits, they're expressly including the cost of preparing reports. And when they talk about the cap, they omit those words. And we're putting some significance on that, although members of the Financial Services Commission have indicated their view that the $2,000 cap would incorporate the cost of preparing reports. Our interpretation is a little different by virtue of this omission, which we're interested in taking issue with.
The next major change that we see comes in regard to the completion of the Form 1 assessment of attendant care needs. In Section 42.1, again, we've put up this slide for you. I'm not going to read all of the section for you because most of the section is the same. The change occurs in paragraph B. And so this is where the big change comes. Now, under the new SABS, only an occupational therapist or a registered nurse can complete the Form 1 assessment of attendant care needs. Another section that we don't have up on the slide but you should be aware of is that in Section 25.1 of the new SABS, and it's paragraph 4, so you may want to make a note of this, 25.1 paragraph 4, it allows a Form 1 to be completed at an insurer's expense without prior approval. So it's an important section to pay attention to. The second aspect of this change talks about a guideline. And you're going to hear a lot of people talk about guidelines. Willie talked in his opening remarks about guidelines in various different areas that are going to be prepared. The guideline has not been released at this point. There was some talk initially about a requirement being added to this section about completing the Form 1, that in addition to only allowing OTs and RNs to complete the form, there was some initial talk about that those people had to be trained in a specific way. Maybe these things are going to come out in a guideline. We're not sure, but these are things that we're concerned about. We're also concerned about any other type of restrictions that may come through a guideline. So we have to wait until the guideline is released, and then we're going to see whether there's any further restrictions on completing the Form 1 beyond this change, which requires that only OTs or RNs can complete the form.
Point number 4 on the list, the new treatment and assessment plan. And Willie mentioned it. The process changed. No longer are there OCF 22's requests to assess. Gone. Everything is going to be done by a new OCF 18 form, formerly the treatment plan, called the treatment and assessment plan. Okay? So that's the new system. What's caught in that is the new treatment and assessment plan requires a signature. The old OCF 22 made the signature of the insured person optional. And on the new OCF 18, it's expected to be mandatory for the signature. That's what it says in the reg. And it's expected that's going to be enforced. So from now on, lawyers are going to have to do a better job getting some forms signed by their clients and have them confirm verbally so they can submit it without delay, because that can be a major delay if somebody's in hospital or in a remote location to get your insured person to sign a now treatment and assessment plan. So that's just a tip. In terms of what you don't need prior approval for, We're going to talk about the deadlines momentarily. There are a few exceptions where you don't need prior approval of a treatment and assessment plan, and those are laid out in 38 sub 2. One is where it's waived. Okay, that one's easy. Number 2 is emergency services, and we haven't put the quote in because it was hard to fit in, but I'm going to just read it to you because there is some importance to this. You don't need prior approval where the expense is for, quote, ambulance or other goods or services provided on an emergency basis, but not more than 5 business days after the accident. So, if for the people who work in hospitals here, if you have somebody who's in need of a wheelchair, and you know that right off the bat, if you want to make sure you don't have to deal with potential delays, if you follow this 5-day, which is really 5 business days, so a week, requirement, you can do it without prior approval. Okay, so it can be funded, and under Section 25(1), you'll be able to get paid pretty much automatically because it's a deemed pre-approval. There's also under C some pre-approvals for minor goods under $250 and for drugs prescribed. But again, the preamble to that uses the word reasonable and necessary, so it's unclear what strength you'll have relying on that deemed approval, where somebody could object to it as having not been reasonable and necessary.
As both Willie and Darcy have mentioned, this new combined process where it used to be a request for assessment followed by a treatment plan, now combined into one. So, what are the deadlines that apply to responding to these treatment plan and assessment plans? You'll recall that under the current SABS, that an insurer is required to set up their insurer examination following the denial of a benefit within 30 days following the notice from the insurer that they want to conduct an insurer examination. And that's found in Section 42, bracket 11, number 2. So that's the current time period that has to be dealt with. To correspond to this new procedure, insurers now have 10 days to respond to the new treatment and assessment plan. You'll recall previously they had to respond within 3 days to a request for assessment. So this is a change. It's now been expanded to 10 days. The problem that we see with this section, and this may be an omission, is that unlike the old legislation, which set out the 30-day window to set up the insurer examination in the case of a denial, there's nothing in the current SABS which requires the insurer to set up their insurer examination within any particular period of time. It just says it has to be done at a time that's convenient to the insured person and a bunch of rules regarding how to convenience the person. But it doesn't say it has to be done within a specific period of time. So the problem with that, obviously, is the insurer says, we don't agree that we need to pay this benefit, and we want to have this person assessed. When are they going to do it? How long do they have to do it? And how do we enforce or force them to do that in a timely manner? So we see a problem with that because that 30-day window that used to be there, which was a check on the insurer and making sure that they did these things in a timely manner, that's now gone.
Just to follow that point up, there's also no deadline on when, after completing the IE, if there's an appointment tomorrow, when the report has to be sent to the insurer. So the rehab company can sit on it. And only when they provide to the insurer, there's a window when they have to send it to the claimant, but there's no deadline for when they have to send it back to the insurer. Rebuttal reports, simple point, they're gone. There's no more rebuttal reports. So if one of your treatment and assessment plans are denied, even if it goes to an IE, you're not going to have the right to rebut or at least be paid for any rebuttal. So that must be very frustrating knowing you're not going to have an opportunity to correct major mistakes made in an IE, whether factual or otherwise. So that's a major change. When it comes to CAT applications, that's a very significant change because often the insurers would set up several IEs to assess the person, and they still can under this system, the one or more assessments, $2,000 per albeit, but they have no limit on how many they can set up, and it doesn't come out of the claimant's money, and you'll have no right to rebut. And if you try to rebut by sending in a new treatment and assessment plan, that's coming out of your client's money. So very, very difficult to dispute denials, at least by generating additional medical support for that.
The next major change, which I've already heard from a number of people, causes some significant concern out there, is that the insurer under the new SABS is not responsible to pay for a future care plan, a life care plan, or any similar type plan. This has been an area of particular sensitivity, I think, to accident benefits insurers. Whether it's right or wrong, and I don't particularly agree with it, but there's been a view, I think, among the insurers. They perceive that these life care plans or future care cost reports have been generated primarily for the tort claim, but that the accident benefits insurer has been required to pay for them. So it's been an area that they've been quite upset about, and in the new legislation, we have this new section which says they are no longer responsible for having to pay for those kind of plans. One concern that we have is the final wording of Section 25(5)(b), where it clearly says the insurer shall not pay for any amount in respect of fees for preparing a future care plan or life care plan or similar plan. That's what I just took you to. But then there's these little tag-on words, and it's always the tag-on words that give me concern. It says, or for any assessment or examination conducted in connection with the preparation of the plan. Now, you can certainly imagine there are all kinds of assessments that may go on that a future care plan would have reference to when they're putting together a future care plan. Are all of those type of assessments going to be captured by this section as well? We don't have an answer to that, but it's certainly a concern that we have. The big point, obviously, is that the cost of these reports are going to have to be funded in some other way. If there's a tort claim, that shouldn't be a big problem. There will be some people talking about some other ways that we may be able to get around this section later on in our program.
The next point initially caused us some concern, which is the change in the medical rehab section to other goods and services being of a being medical in nature, in quotes. That's different from the former SABS rule regarding other goods and services, and we thought that could be significant, and it may be an attempt to close the door on services like nanny services or guardianship costs or legal fees that are sometimes advanced against accident benefit insurers. There is, though, in Section 16.1, under the rehab section, it remains the other goods and services without the reference to medical in nature. So there may be a solution there by just going to the rehab section and avoiding reference to the med rehab section, which now incorporates these words medical in nature. So it may not be of large significance, but it was a change that we thought was notable.
Probably one of the most significant changes that we're going to deal with today is a new definition contained in the SABS of incurred expense. You heard Willie talk about this, and that the perception has been that there was a movement away in each of the subsequent pieces of legislation from what was originally intended when the words incurred expense were added to one of the predecessors of the current legislation. And as a result, there is a very new and difficult definition of incurred expense. This change is so significant that we've devoted a complete section of the program to talk about it. Craig Brown's going to be reviewing this new definition and the implications of this definition later in the program.
Currently, on the current SABS, there's a 2% compounded per month, sometimes referred to as a penalty interest provision, which says if an insurer doesn't pay you on time, they incur interest. The benefit owed incurs interest at 2% per month. Now, that is an outstanding amount. In 3 years, it doubles the amount owed. It's compounded. It's a big difference. It's not simple interest. So this has been reduced in the new SABS to 1%. So it takes the hammer we used to have to say, well, you can keep delaying, you're going to be proven wrong, and you're going to owe double the amount you owed due to the delay. It turns that into a bit of a stick. And it's still there, and it's still helpful, but it takes a lot of the thunder away from that argument, because after 3 or 4 years, the numbers became astronomical. When it comes to accounts outstanding as of September 1, so if you have outstanding invoices or benefits still owed to claimants, we understand the SABs are to be interpreted that it's 2% up until September 1st, and for the period thereafter, it's at the reduced 1% rate. You
all know that under the current legislation, a claimant has to make an election early on as to whether they want to claim income replacement benefits, non-earner benefits, or a caregiver benefit. Nothing new there. Under the new legislation, you still have to make that election. The difference, the change, is contained in Section 35(3). The applicant's election under subsection 1 is final and can subsequently be changed only if permitted under subsection 2. So generally what it means is you cannot change your election once you've made your election. This is a big change from the current system where there are circumstances where you are entitled to change your election. The only time that you will be allowed to change your election under the new SABS is if you later apply for catastrophic determination or catastrophic impairment designation. And if you are found to be CAT, when your injury was initially not catastrophic, then you have an option to revisit the election that you've made at that point.
Discretion. Discretion from adjudicators, from adjusters, excuse me. Adjusters now have discretion, and that is a major change. Before, any denial had to follow with an IE, which often the IE came back supporting the denial, to be frank. But this is a big change. Now they don't need to do the IE. All the provisions we've cited here deal with all of the benefits. The specified benefits are the weekly ones, the income, non-earner and caregiver, as well as the housekeeping, and then there's the med rehab reference to 38.8, attendant care, and even CAT under Section 45.3. An insurer can deny a CAT designation for medical and any other reasons without needing an IE. Now, realistically, the adjusters are going to be scared to rely on this without an IE, and we don't anticipate too many denials in cases of CAT applications, for one, without an IE. But slowly over time, who knows how that's going to be used and how people, especially unrepresented people, may be treated in light of this discretion from adjusters. What in the world medical and other reasons means is not defined. Because every denial now must say, for medical and any other reasons, we're denying it. It's not reasonable and necessary anymore. It's medical and any other reason. So we expect the fallback to be on what may be seen as medical reasons, such as there's not enough medical information to support the need, and that's our medical reason. Or the records don't make it clear that this has been recommended from a medical perspective. So nobody really knows how that's going to be interpreted, but the denials are going to have to come with some medical and any other reasons. And the word "and" is used, so it's not medical or any other reason. There has to be a medical reason. There can be other reasons as well. So we're concerned about this, and we will see in the next couple of years how this ultimately plays out.
Another new creation of the SABS, probably to tie in with the fact that now your assessment costs come out of your med rehab limits. There's now an obligation on insurers to provide what's called a benefit statement. So this benefit statement has to be sent to the claimant, the insured person, and it has to advise that person of the amount paid to date and the amount remaining under each of these categories: medical and rehab benefits, attendant care benefits, and the amount that the insurer has spent on Section 44 insurer examinations. It used to be Section 42 examinations, they're now called Section 44 examinations. So the insurer now has an obligation to send out these benefit statements to keep an insured person apprised of how much money is being spent on their file. That's essentially what this section is saying. How often those benefit statements have to be sent out? Well, in a non-catastrophic case, every 2 months, unless the amount hasn't changed. So if the insurer hasn't spent anything more since the last benefit statement, you don't have to send a new benefit statement. In catastrophic cases, at least once a year. Now, one may ask, does this section apply to accidents prior to September? And while Richard's going to be going into the transitional rules in some detail, I just wanted to mention here that our information is that this rule does not apply to accidents prior to September. So insurers are not required to send out these type of benefit statements for accidents prior to September 1. One curious thing that both Darcy and I noticed in this is while it's required that the insurer provide a benefit statement that that tells you how much has been spent and how much is remaining under the medical and rehab benefits or the attendant care benefits. They've also added this, how much has been spent on insurer examinations. I find that somewhat curious because it doesn't come off of the limits. So one wonders why it's been required that information be provided as well. Maybe it's been put there to try to allow people to have some gauge on whether an insurer is dealing with the insured person fairly. In other words, comparing how much have they spent on assessments to how much has the person received in benefits. I don't really know. That's just my guess.
Accounting reports. The new SABs provide that the claimant, the insured person, has up to $2,500 to spend on an accountant to quantify the value of their income replacement benefit. And that is, the section refers to one, it can be as many assessments as you want from the accountant, but the cap is really $2,500. It does not come out of med rehab benefits, as we've discussed. And while this section seems to be a decent change, it doesn't preclude how much an insurer could spend on responding to an income replacement benefit determination. So if your accountant spends $2,000 worth of time to quantify your income replacement benefit, the insurer is free to spend a lot of money responding to that. So it doesn't restrict how much an insurer could spend for those accounting reports, which causes us some concern.
Just to pick up one point on this issue of accounting reports, you have to recall that under the new legislation, under the new SABs, as Darcy mentioned, there's a change in the way income replacement benefits are calculated. It used to be this very cumbersome and difficult calculation of 80% of net income, which caused no end of trouble. We spent more time trying to figure out what is a person's income using that test. So the new legislation's tried to simplify that a little bit by saying it's 70% of gross income, which should be an easier calculation. And to go hand in hand with that, they've put this restriction on the amount that can be spent on the cost of accounting reports, because as I understand it, the intention here is to try to simplify the process, reduce some of the cost, reduce some of the expense that has been spent currently on trying to prove something fairly simple, which is what is a person's income, all right? Yet tons and tons of money was being spent trying to determine what a person's income is, and tons of money was being spent on accounting reports going back and forth trying to determine what that amount should be. So that's just an additional point that I think talks about that. Transitional issues. I'm not going to steal the thunder of Richard, who again, this is a very major area under the new legislation, and we have devoted another section that Richard Halpern will be speaking about, the transitional issues. There are all kinds of questions that arise. You've heard a couple of them already. I've thrown a couple up here on the slide. Does the $2,000 assessment cap apply in cases that predate September 1st, 2010? The answer that we've determined is yes. Richard will tell you how we get there and why that answer is what it is. Another question that may jump to your mind is, does the new definition of incurred expense, which we've told you is a big change and a major change in the new SABs, does that apply to pre-September 1, 2010 accidents? The answer we've received from representatives of the Financial Services Commission is no. But once again, Richard will take you through, when he talks about transitional issues, how do we get to those answers? And there will be a lot of other transitional questions that Richard will be taking you through in his presentation.
Again, the issue of minor injury and the guidelines that are anticipated is subject to a separate presentation today. It's a big topic. It has significant consequences. So we're not going to get into that in our overview, but we did want to make sure that everyone understands this is a significant change and it should be part of the overview. The guide is not yet out as of today. There are a lot of people here that have seen drafts, and there's some discussion going on. Most of that is confidential, but there is no official guideline that is public at this point. It does replace the old pre-approved framework. It's meant to cover the WAD 1s and WAD 2s, and the question is, does it go further than that? And the guideline may have some role in that discussion, that debate.
Richard and Willie told you at the outset that generally the catastrophic claims have been left virtually untouched in the new SABS, with a couple of minor changes. The one change to the definition of catastrophic impairment is a change in Section 3.2. It's a welcome change, one that we've been advocating for years, and one that we're happy to see has been included in this version of the SABS. Section 3.2b has been amended to say that the amputation of an arm or leg or another impairment causing the total and permanent loss of use of an arm or a leg is now going to be considered catastrophic. This was a major gap under the old legislation. As you know, a single limb amputee was not automatically considered CAT. Under this legislation, it will be. So that's a welcome change to the definition. As a result of this change, you will see, and this is a little bit confusing, but you will see when you go through the actual SABS, through the new Statutory Accident Benefits, there's a numbering change, because there used to be two sections dealing with amputations, two letter paragraphs. So B and C have now sort of been combined into this one B to capture the single limb amputee. And as a result of that, all of the letters in the section on catastrophic have moved up. So it's going to be confusing, because where you're used to hearing people talk about, for instance, combining sections F and G, now you're going to be talking about combining sections E and F. All right, so that just adds a little bit more confusion to the mix. It's something you should be aware of. Under the catastrophic section, the lettering is different. Otherwise, no major changes except for the change adding the single limb amputee or a person who has suffered complete loss of use of one limb.
The next point that deals with the catastrophic issue has to deal with timing. The catastrophic definition has some tests that kick in immediately following the accident, like the GCS test. Other tests, like the Glasgow Outcome Scale, that come in a little bit later. And it also has some tests that come in even later than that. And those tests are now in E and F, formerly F and G. And those are the 55% whole person impairment test, along with the marked extreme mental or behavioral disorder test. It used to be that if a health practitioner thought the injuries were permanent and therefore unlikely to cease, they could sign a certificate, an OCF 19, an application for catastrophic determination, within that 2-year period, as long as it's unlikely to cease to be a catastrophic injury, based on those tests. The new change is that there's a mandatory 2-year waiting period, except where achieving that test incorporates a brain impairment. Okay, so if you look under A, it deals with an impairment that includes a brain impairment, being able to access the test before the 2-year mark. And again, we're talking about the whole person impairment and the marked extreme test only. And the second one is if there's only a brain impairment, it can be dealt with by a neuropsychologist. In fact, it says it must be dealt with by a neuropsychologist if it's only a brain impairment. And that's the way I read that. In the case of an impairment that is only a brain impairment, a neuropsychologist states. Okay, so that may, in exclusively head injury cases, you may be restricted to that. And that has some consequences to people with very serious orthopedic injuries, combined with some psychological injuries, but not a brain impairment in that sense, although there may be attempts to categorize it as a brain impairment, and there may be a brain impairment component. But for those people with the orthopedic injuries combined with the psychological, they're going to have to wait 2 years. You cannot access these tests until then, and that is a problem. And one problem that it raises is what used to be an extension provision, and the extension provision is still in the SABS. It's in Section 45.4, and it says attendant care can be extended, essentially, if you apply for CAT while you're still getting attendant care benefits. Okay, so we have a lot of cases where you're getting close to the 2-year mark, and as long as you're still getting attendant care and you're going to battle on the CAT front, you can apply, and they continue to pay, and they continue to pay on the CAT basis. So they've been paying you up to $3,000 per month until then, and when you apply, you're all of a sudden up to $6,000 because you're deemed CAT until the issue is resolved, by way of IE, that is. That's now narrowed because you can't get to the test until 2 years in a lot of these cases, and because the attendant care, a non-cat, has been reduced to $36,000, which covers 1 year at the full rate of $3,000 per month rather than 2. So in most of these serious cases, the attendant care is going to be completely spent after 1 year, and they're not going to be eligible to apply until 2 years. So one solution we have for that problem in trying to access this clause, this extension clause, Section 45(4), is to leave some money in the bank. So the lawyer, when they get these benefit statements and see how much is spent on attendant care, should recommend that a few dollars or a few $1,000s is saved and held back, so when you're eligible to apply for CAT, you can take advantage of this provision, which extends it at the enhanced rate until the issue is resolved, pretty much.
Just as an addendum to that point, one other example that you might want to consider, which is an obvious problem that we can see here. You've got a person who's seriously injured, as Darcy said, with orthopedic injuries. Let's talk about somebody with orthopedic injuries. We know that the med rehab limit has now been reduced to $50,000. One can anticipate that that's going to be used up fairly quickly. If they have to wait 2 years before they can apply for catastrophic, what's going to happen to that person? When the money runs out, up to the 2-year mark where you can apply to have them deemed catastrophic. That's going to be dealt with, I believe, by Sloan in his paper. It's a very serious problem that we have to address, and Sloan will help you through that. The next change that we find in the new SABS is in Section 45(2). We've put up all of Section 45 on the screen for you. You don't have to read through the whole section. The highlighted in red portions are really where the change comes. Pursuant to Section 45(2), only a physician or a neuropsychologist may now sign a CAT application. And that ties in with other sections in the new SABS that Darcy's just talked to you about. So if the injury is some injury with a combination of a brain injury, then a physician can sign the form. If the injury is a brain injury only, there's an additional person that could sign the form. That's a neuropsychologist. So it's not an exclusionary thing. It's not, it has to be a neuropsychologist. It may be a neuropsychologist. So does everyone follow that? If it's an injury that includes a brain impairment, so some other type of injury plus a brain impairment, a physician can sign. If it's exclusively a brain injury, it can be either a physician or a neuropsychologist. Again, we see this reference to guideline in this section. And the guideline is not out. We don't know what the guideline is going to say or how the guideline is going to further refine the CAT application process. But again, very concerned that if a guideline attempts to further restrict or narrow the process, this is something that we have to watch for and be careful about and certainly argue against. It shouldn't be done by way of a guideline. If there are going to be those type of substantial changes, they should be made by way of regulatory changes as opposed to through a guideline.
And we're just coming to the conclusion of our presentation. In the coming weeks, we're expecting more information. There's been talk of a transitional provisions bulletin from the Financial Services Commission or something along those lines that'll help explain how they understand the transitional section is supposed to work. The minor injury guidelines are in the works, and those will be released in the next few weeks, we expect. One thing that's not in the SABS are the promised amendments to the Insurance Act to address the fatality, the elimination of the deductible in fatality cases. So there have been no amendments in that regard yet. It would not be in this SABS. It's properly an amendment to the Insurance Act, not the regulation for the Statutory Accident Benefits Schedule. But that amendment's not been made, and we're waiting for that because that's an important compromise in this, these changes that have been announced. One issue I want to highlight, and it may lead into what I think is going to be some question and answer period, is the initial press release from the minister referred to the new SABS. Assessment costs would be limited to $2,000, quote, and the fee for completing forms, including any assessment required to complete the form, would be capped at $200. There's nothing in the SABS that deals with this announcement. There has been some recent discussion about something that may address this issue. It's a cause for serious concern in so much as it may, if announced, cover the maximum amount payable for completion of a Form 1, for example. So that's an issue we're going to be watching. We refer you to our website, thomsonrogers.com, for updated information. Anytime there's a guideline announced, anytime there's something public, we will post it on our website. We're on top of it. We ask you to refer to it for questions. I also, again, Len and I put together a very comprehensive paper at tab 3 incorporating a lot of the input from people like Karen Rukas, who I want to thank, and other lawyers at the firm like Richard and David Payne and Craig and Sloan and everyone else who's presenting today regarding the new changes. And if you have questions, I hope that you'll find most of your questions are addressed in that paper at tab 3. Thank you.